everybody on behalf of the MCIA for one, coming to the India ADR week and making it an absolutely super success. I'm sure at the end of Justice Roy's speech you will hear about how successful it's been, but from whatever little tidbits that I have been given, I think it's been stellar in all the three cities. I also have the privilege of introducing Justice Hrishikesh, who is currently the 5th senior most judge of the Indian Supreme Court, and in fact, interestingly, is from the 1982 batch of India's leading law school, which is in the University of Delhi, which is where I also studied, which has in fact produced 4 judges of the Supreme Court, including the current Chief Justice. So I think some part of the pedigree seems to have done up reasonably well on the younger folks. Anyway, coming back to this, I wanted to, a lot of people in the room have heard of Justice Rohinton now. And many years ago, Justice Nariman went to Mumbai and gave a speech on the value of a dissent. And then when he was writing a judgment on the right of privacy, he actually wrote a bit about the value of the dissent. And what he said is that the Indian Supreme Court owes much of its intellectual foresight and bravery to dissenters. And he names some stellar judges. Justice Fazal Ali, Justice Subha Rao, who were judges of the Indian Supreme Court, because their dissents on matters such as the freedom of speech, the right to privacy, eventually in time became part of the judgments of courts because their dissents became part of the majority decisions in larger benches, which took a couple of years, but it got there. Well, on the arbitration front, Justice Hrishikesh Roy wrote a dissent not very long ago in a judgment which is very well known as NN Global 2. Arbitrations in India were getting stalled. They were getting stalled because when an application to appoint an arbitrator was filed, an objection would be taken that the agreement was not properly stamped and hence was unenforceable. And judges had to grapple with that issue. In NN Global 2, Justice Roy wrote and said, you cannot conflate the concept of existence and validity of an arbitral agreement, and when an appointing authority is required to appoint an arbitrator, all that it needs to look out for is the existence of an arbitration agreement. He was one out of the 4 judges who took that point of view. Very quickly, in a couple of months, that decision went up to 7 judges. And Justice Roy was found to be correct, and 7 judges of the Indian Supreme Court have now taken the view and have said that his analysis is correct. I mean, that's Justice Roy. He stood up for what he believed in, didn't get called down by 4 other judges. The effect of it is that today, if you have a non-stamped arbitration agreement, you cannot derail the appointment of an arbitrator. I'm sure Justice Roy will certainly discuss more concepts on arbitration or other aspects with you later this evening. But let me tell you, Justice Roy, apart from being a judge and being a pedigree of exceptionally good law, has many other interests. One is theatre. Gaurav was in fact, Gaurav Banerjee, who's right here, sent me an article which I couldn't open because I don't subscribe to light law, which actually has an entire interesting discussion of how he was sitting in the Supreme Court and there was an entire conversation about his love and interest for theatre. Perhaps he'll talk to you about that later today. But, and as I said this, he's also got an exceptionally great sense of humor. Sometimes it's wicked. And one time it was wicked was on me. I met him at a dinner organized by one of these international arbitration organizations. He walked up and he said, Nakul, there are a lot of people talking about you in the other room. And that like brightens you up, right? I mean, you're going, come on, I mean, this is really good. He says, but none of them said anything good about you. So ladies and gentlemen, on behalf of the MCIA, I'd like to welcome Justice Roy and thank him for agreeing to be the chief guest this evening. Thank you, sir.
I always thought Nakul to be somewhat bright, certainly, but not a very naughty person. But I see another characteristics of Nakul as he was introducing me. Today, of course, is the day of the Mumbai Center for International Arbitration. I was just speaking to Neeti and I was telling her how you still have your smile intact with so many things going on and so many things capable of going wrong, people not turning up, something not happening, the caterers have given up, so many things can go on, and yet she had that very bright smile. But thank you very much for giving me this opportunity. It is really a privilege to speak in a gathering of professionals who, like me, believe in the power of arbitration as a key alternate dispute resolution mechanism. Arbitration was once envisaged as a fast, flexible, cost-effective solution to resolve disputes outside the court system. It was to be the knight in shining armor, sweeping disputes off their feet and delivering swift and fair justice without the cumbersome formalities of litigation. And yet, as we sit here today, arbitration is no longer the sleek sports car that we once envisaged. Instead, it has become more like an overloaded truck strolling up the hill while we watch from behind, wondering, wasn't it supposed to be faster? The frequent adjournments in arbitration proceedings are often driven by part-time arbitrators and lawyers juggling court appearances and arbitration hearings. I'm sure many of you have the experience of arbitration proceedings being kept on hold because a lawyer is rushing from the court to an arbitration hearing with the infamous reason of being caught up in the court. We are slowly turning arbitration into what it was never meant to be. Just another formal process with more adjournments, more delays, more paperwork, and less arbitration actually getting done. Frankly, our lawyers and judges have not only treated arbitration as an alternative dispute resolution mechanism, but have also treated arbitration as a second calling after their regular court appearances. Attending in court is important as it provides a degree of recognition amongst your peers, your colleagues, but at the same time, unless we have committed bar members attending to arbitration in more or less in an exclusive fashion, the professionalism needed in the field of arbitration is unlikely to develop into a dynamic entity we all hope for. Arbitration, I feel, is burdened with too many practicing lawyers who attend court full-time and then, time permitting, also attend arbitration. Likewise, far too many retired judges are acting as arbitrators in India. Sometime back, a friend told me, and this I think is appropriate because you are having a cricket match tomorrow, scheduled between, which are the teams? Right, so two teams playing cricket, locking horns tomorrow in the cricket field. Now this is something which a friend told me, a fictional conversation between Sachin Tendulkar, who is the legendary cricketer, and Roger Federer, who is the tennis legend. Now Federer tells Sachin that India is the world's largest market for tennis balls and rackets. Sachin replies with affirmation and says that we love tennis, but cricket is our first love. Federer follows up and asks if Indians play cricket with tennis balls. Sachin says yes, to which Federer asks, then what do you do with all the rackets? Then Sachin Tendulkar, he replies, we connect batteries to the tennis rackets and kill mosquitoes with that. I hope we don't do the same thing with arbitration and make it something else. Arbitration practice needs to shed its legalese robe. We need to move on from the mentality of choosing legal in devil wear Prada dresses and pinstripe suits as arbitrators, and instead choose people who can promise their time, efficiency and quality service. Recently, the Chief Justice, who Nakul so graciously has introduced as my class fellow in the law school, informed that in course of his court proceedings in courtroom number 1 of the Supreme Court, he appoints young, talented lawyers as arbitrators with expertise, skill, rather than retired judges. The number of arbitrators amongst lawyers that he has appointed is outnumbering the retired judges that the Chief Justice is appointing. So true strength of arbitration lies in its flexibility in appointing those best suited to resolve the particular dispute at hand. Another crucial recommendation for reforming arbitration practice in India has been to appoint genuine experts from the concerned field as arbitrators. In international commercial arbitration, oftentimes a quick, not so expensive, and yet expert resolution of the dispute is elusive. While we are talking about arbitration, I am reminded of a story, not of mine, but of Professor William Parr of the Boston University, who used to describe arbitration and its deficiencies. This story goes like this, and some of you might be familiar as well. There is a sign in the window of a shoe repair shop in downtown Boston. It is run by a Greek immigrant who is fed up with customer complaint. So he puts up a sign with a triangle connecting 3 different expressions. The top of the triangle has fast service. One of the bottom has low price, and the other side of the bottom of the triangle is high quality. And at the top of the triangle are the words, and underneath the triangle is the all-important instruction, pick any 2. Because if you think a little, you will understand all 3 things together, fast service, low price and high quality, at the present moment are simply unattainable, particularly in the international commercial arbitration and in international investment arbitration. Therefore, if we have to have fast service, we must recognize the efforts made by an arbitrator to not only provide high quality service, but also prepares and delivers awards within the permitted time. In the context of speed of disposal, how can we forget another stalwart, in fact a true stalwart, emerging from the Bombay bar and shifting to Delhi. Fali Nariman is the man that I am talking about. Now Fali Nariman, he narrated the story of an Indian visiting London. And the Indian gentleman in London, he came down with a toothache and it was unbearable, so he needed to consult a dentist. So he went and had fixed an appointment and went and met the dentist. And asked the dentist of the procedure that he intends to sort of undertake to cure the pain. And then we as Indians, we have this thing about knowing the price of the procedure. So he said, Doc, how long would the procedure be and what is the cost? So the doctor said, the dentist said that it's going to be just a couple of minutes and my charge will be 300 pounds. The Indian was aghast. He said, 300 pounds for a procedure lasting 2 minutes? Now this was a story told by Fali Nariman. So I'm just narrating what he said on another occasion. So the doctor who had such experiences with patients, he said, if you feel more comfortable, he told the patient, if you feel more comfortable, I can extract your tooth very slowly so that you will have a procedure which might last longer than 2 minutes and yet you will feel that 300 pounds is worth the procedure that was undertaken by the dentist. Now, ladies and gentlemen, the choice in the field of operation is sometimes people feel short-charged when they are not rendered on time, but there are occasions, and I'm sure you had pleasant experiences also of arbitrators rendering award in good time, and in that situation, such arbitrators will also require a bit of your recognition. Recognition in terms of getting quality work, recognition in terms of proper remuneration, because very often the process gets elongated because people have a system of, not only I'm talking about the arbitrator, but also the lawyers who are appearing before the arbitrators, on a per day appearance fee basis. So sometimes things get prolonged because of that also. So that is something which we can always address. Now arbitration, like we also have the mediation, requires a fine balance of several key elements to ensure its effectiveness. Accuracy, fairness, cost, speed, enforceability of the award. The same Professor William Parr, in his article, Arbitration and Fine Dining, Two Phases of Efficiency, provides an analogy to illustrate the balance. Now, we are sitting in a hotel banquet hall where dinner is awaiting. So, think about a restaurant which provides quality food. You visit this restaurant which has the reputation of providing quality food, but suppose food arrives much delayed, or you go to a restaurant where food arrives promptly but the quality of food is not very good. So therefore a chef has to focus not only on one aspect, but he has to focus not only on the quality of the food, but also on how quickly he can deliver the food. Balancing both is very important. So similarly, in arbitration also, we need to balance all the desired elements to ensure that there is a positive experience to be earned. And just as we need to focus on arbitration, similarly, a chef in a hotel must balance timeliness, quality together in order to give a wholesome experience to his customers. Now, in India, we are having a situation of arbitration to avoid the procedural complexities, and it was expected that it will shorten the delays in the litigation which are pending in court. While party autonomy forms the foundation of the arbitration process, the intervention of courts is fairly frequent. Practically, the arbitration has turned into a two-step process. Arbitration followed by a trip to the court. This begs the question, is arbitration truly an alternative dispute resolution mechanism when you end up in the court anyway? As another time Professor Park had said, fairness requires some measure of efficiency, since justice too long delayed becomes justice denied. It is a balancing act, really, to say. Too fast and we lose substance, too slow and we have the very reason arbitration was designed as an alternate in the first place. Where arbitration reforms such as the 2015 amendment and 2019 amendment have aimed at expedition, quickening the proceeding, it is critical to remember that efficiency is not the end goal. Fairness and legitimacy are the true benchmark of a well-run arbitration. So how to reconcile these competing demands? As we move forward to our quest to improve arbitration, we need to steer the process in a way that delivers reasonable speed without compromising on due process. As we have seen, I am being asked to speak in this forum. He's mentioned about a particular judgment that I wrote, a dissenting judgment which got endorsed by a larger bench. The dissenting view got endorsed by the larger bench. And a couple of other judgments that I wrote, which I don't wish to speak about. But definitely, I must appreciate the opportunity to speak with you today. Thank you.